I'm doing this webinar slightly different than I have in the past. Normally I would do it live, so I'd know that people signed on and I could check the audio and the visual, but I'm actually doing this as an on-demand. So I'm recording it from the privacy of my home, which will also explain why you may hear some landscaping in the background and maybe several dogs barking. So today's webinar is 6 valuable child insights for divorcing dads. And this will be actually applicable even if it's for unmarried couples with custody agreements, but it's geared towards divorcing couples because sometimes it's a little more complicated because you have surrounding issues such as assets and debts, distribution, relocation issues, and things that often come up in divorces that don't always come up when unmarried couples who often live separately. But you can use it either way, so I'm going to try my best to keep it even based for both types of couples. I also have my camera on, but again, I'm not sure how it presents in this recording, and I want to just take a second to make sure that we are recording, because I'd hate to spend all this time talking and not have anything to show for it. So let's quickly move on. My name is Brad Micklin, as I said. This is a picture of me for those who haven't worked with me. I am a licensed attorney in New Jersey State and Federal Courts. Been practicing since 1996, I think it is. The founder of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. As I mentioned, we are concentrated on empowering men and fathers in divorce and custody matters. Here are several awards I've been honored to receive in the past. I don't put these up to try to impress people, but to impress upon you the experience that I have and that you can trust in the tips and advice that I'm giving you here. There are also some appearances I made, national appearances on Inside Edition, the late Larry King, obviously before his demise, some Fox News, and many others. Again, this is just to show the range of my experience and with the hopes of giving you confidence that this webinar is going to be helpful for you in your current and future situations. All right, so let's jump right into it. First slide is to retain an attorney who concentrates in family law. And first, there's a distinction in New Jersey with certain practitioners where there is a specialization and a concentration. So attorneys who are quote unquote specialized will have a civil attorney icon on their letterhead, and those who concentrate in family law like myself don't. The difference is essentially a very tedious, long test that one takes. I never saw any benefit in obtaining it, so I never did it. Not to say that there's not value in it. It's something that you can use when evaluating who to choose, but there is a distinction. So you'll hear people say specialized or concentration. I say concentration, just so that we're clear about it. So things you want to do when you hire an attorney, or at least don't do. First is don't hire a general practitioner. And I don't say that because I'm not one. I say that because there's a lot of value in concentration, which is why I chose to do it many decades ago. First, we have a greater ability to spot the issues that you either have now or will have in the future. Being exposed to such a high volume of similar cases, you get to see patterns and similar fact patterns that a general practice attorney just simply doesn't have. It also allows us to have a better practice and more streamlined. We'll have documents, for instance, that will address issues that you both have or will have in the future that you might not have contemplated, and certainly a general practice attorney with less experience may also not foresee or plan. It's also usually less expensive, even though you sometimes are paying or often are paying maybe a higher rate, but you're getting better work. I always say cheap is never cheap. So just because you might be paying less per hour, you might spend more time having things drafted or negotiated because they just don't have the mechanism or the streamlined process to accomplish things as quickly or as easily as a concentrated or specialized attorney will. Another thing to avoid is what I call an old-fashioned, outdated attorney. There are a lot of like good old boys school mentalities that still exist both in men and women attorneys. There's a common belief of traditional values. And it's usually with older attorneys. I mean, not that I'm as young as I would like to think, but you'll see with a lot of older attorneys, again, men and women, who believe that men should have traditional parenting time, which is like an alternating weekend. Mothers should be the primary caregiver. It's not really based on law or science. It's just based on an old mentality that pervades the legal system today. You'll also see this is what often many judges still bring into the courtroom, even though the laws have changed significantly. I tell my clients laws have changed, but attitudes have not. So it's our job to do the opposite, and that's to pull you in the right direction and educate people that the laws, and many we'll discuss in here today, have changed, but people don't recognize that, or at least like to acknowledge it. So you don't want somebody who just thinks you should be a weekend dad and accept that role. It's not current, it's not appropriate, it's truthfully unconstitutional, and it's unfair. All right, so let's talk a little bit about how your attorney is going to operate and things you should know. Never, ever sign anything before consulting with an attorney. And even if you're not going to go to a concentrating attorney or somebody who specializes in family law, even if you're going to a general practice attorney, speak with an attorney before signing anything. Even if you're not going to hire an attorney, you can usually get a consultation. Many, if not most, are going to be without charge. So you can at least find the issues that you need to be aware of. In my experience, because we deal primarily with men, there's a certain attitude of, well, I can handle that. Or when things are good, they're good. So let's just agree to this and I'll handle it. And that may work in the short term, but people don't contemplate future changes of circumstances. People generally believe the way things are, the way things will continue. And I certainly hope that's the case, but usually it's not. People need to consider things like disability or unemployability, economic changes, new relationships that either you or the other parent will enter or leave, and how that's going to impact your life, your children, and your custody agreements. So if you're just given something that says, here are the 3 things that you're entitled to, and you sign that, there's a lot of things, and we'll discuss some of them in here, that won't be considered. And if you don't consider them now and mention them, it's going to be hard, if not impossible, to consider and change them in the future. Keep child support out of the custody and parenting time negotiations. And I don't mean entirely. I mean in the beginning discussions. First, the law says, for good or bad, parenting time and child support are separate and unrelated issues, which means even if you don't get the right to see and spend time with your child, you're still likely to be paying child support. The underlying reason is New Jersey, quite honestly, doesn't want to provide welfare to support children, so they make sure there's very rigid policies and practices and laws about child support and child support enforcement. We don't have the same laws about a parent's right to spend time and have a relationship with their child. Fortunately, the Constitution of both the state and federal constitutions provide that you have a right, an undeniable right, to a relationship with your child. But when it comes to negotiation and finances, it's important to realize that they're unrelated. But secondly, probably more importantly, in my experience, and again, I'm going to say this often about men because that's primarily what we represent. It goes both with men and women. So don't take this as offensive. Don't take this as a gender-based issue. But again, my experience is primarily dealing with men. And quite honestly, right now, and I didn't mention this when we started, but today is October, I think it's 1st, 2021. So as things develop and laws change, the opinions in this may change. So we're kind of going on what exists today. But in my experience and with my practice, I see and handle more traditional families. Men are still making more money than women. Women are still more often the primary caregivers of their children. So when I speak about that, that's kind of the backdrop of my experience I'm speaking to. It's not to suggest that that's everybody and that it's a good or bad thing or that it's not going to change. It's just where we are right now. So I digress, but the reason I do is because my next point is that if you are negotiating parenting time and child support, the other parent will often think that you're doing it because you want to reduce the amount of child support you're paying. Because in New Jersey, child support is reduced by many factors. One of them is your overnight parenting schedule. So the more times you have the children or child overnight, the less child support you pay. Now, that's not to say that there aren't some people who do try to negotiate more overnight parenting time to pay less child support. However, anybody who truly understands how the calculation works or looks at the calculation would realize that's just a foolish way to approach it, because it's never less expensive to have a child overnight just because it reduces your child support. The reduction in child support per overnight is so much less than you're likely to incur by having children or a child overnight. You're paying more in food, you're incurring more utilities, you're paying more extracurricular activities, entertainment. Not that I'm suggesting you shouldn't do this, but you shouldn't do it for the purpose of believing that you're going to be paying less in child support, because ultimately you're probably not. And it's going to impact the other side's opinion of your good faith when you're negotiating parenting time. So they're likely to be unwilling or less likely or less willing to give you more parenting time if they think that's the motive. So continuing on. So the next slide says, make sure your lifestyle, housing, and work schedules can accommodate the type of custody and parenting time you're seeking. Basically, that means get the proper accommodations or make the proper accommodations. Now, this isn't to say that you have to have these things in place, but you need to have at least a game plan so that you can tell your attorneys. So you want to look at things like, where are you going to live? If you can, get a copy of the lease agreement, maybe get some photos so that you can show what the housing is like. Not that you need to establish or prove your right to have parenting time, but it's often a concern of the other parent, the accommodations that are going to be provided. And while, again, you don't have to provide this, and technically you don't really have to have it, the law doesn't require that you have separate beds or bedrooms for your children. It just requires that you have proper accommodations so that they're comfortable, they're safe, and the other parent shouldn't really want more than that, but sometimes they do. So take as much preparation time as you can and get these things in place, like a lease agreement, copies of where you're going to be living. Also, try to accommodate or try to provide information about what your work schedule is like, how that may change, whether or not you're going to need babysitters and who they're going to be. You might want to have each side exchange names or have contact information so that you are aware of who's watching your children in their absence. And again, be mindful, this isn't a requirement. When you have your child, you have what's called parenting time. And that's because you're considered to be the parent. So you are technically required to be making the decisions when you have your child. So whether you have a babysitter or not is really your choice. But it's not unusual for the other parent to want to know who's watching their children. This goes both ways. So either you can require that they provide it and you can provide it, or you can refuse to provide it and not require it from them either. But it can't be one way or the other. I'm sorry, it has to be one way or the other. So next, keep a journal or calendar of parenting time events. So there are many things that I think you want to start to log or record or keep track of. Some of it should be sort of an actual record, and some just want to be sort of like mental notes that you make. But for today's purposes, we're going to largely talk about the actual journals and entries and records that you want to keep. So first, keep a record of important conversations. When you are discussing something with the other parent, it is admissible if there is a trial in your future or a conflict. Having notes that you record around the time of the conversation is likely to be considered reliable, and your recollection is going to be weaker as time goes by. So having these notes will help you. Also, it's important to note in New Jersey, and this is important to remember, in New Jersey, you can record the conversations of another person in New Jersey without them knowing, and it's admissible in court. Now, I've done, I think, some videos on that, so I won't go into depth. You can go to my webpage at micklinlawgroup.com or my YouTube page, which is Brad Micklin, and see other videos on that topic. but you don't want to record somebody in another state unless you know what that law is about recording, because it can be a state or federal crime and it's serious. And also, as a quick aside, a lot of judges actually frown upon recording the other person because they know, or they believe, probably rightly so, that when you're recording, you know you're recording, they don't know you're recording. So you're on your best behavior. You're probably catching them at their worst. And they also just don't like things to be any more adversarial than they need to be. That aside, I still tell my clients to record it if they think it's necessary. My opinion is let the judge frown upon it, but if you need to prove something, you need to prove something. And this is too important of an issue to worry about the judge's feelings about your conduct. As long as it's not inappropriate, as long as your conduct is appropriate and lawful, do it. Next, you want to record important dates, children's activities, doctor's appointments, religious events, both current and in the future, so that you obviously don't forget anything and you can make sure that you get involved in all of them. And you can also schedule this into your agreement so that future events will be mutual, that you'll be involved in it, and that you'll be attending them. You also want to write down what their homework assignments are, their teachers' names, their doctors' names, their friends, any kind of important conduct or contacts. You should keep a note. Usually on a calendar is a good way to do it. It's like Google Calendar is usually my go-to calendar for something like this. When things deviate from the regular schedule, when you've had parenting time canceled, or when you were promised time and you didn't get time, when you had to take time because the other parent wasn't available because they had travel, had a conflict. Any positive or negative change in the schedule, you want to be able to reflect it so that you can see first how much time you've had, how much time you've lost, but also contemplate what trouble you may have in the future coordinating it, so that you can build in changes, you can build in what kind of notices you should receive. You can also build in what kind of costs you should or should not incur, like extra babysitting costs and lost work because you had to take off to accommodate a last-minute change in schedule. All these are very important, and you should be contemplating them when you are making custody agreements. I also did some webinars. I don't think they're on my website, but I'm certain they're on my YouTube page. How to use email tactically in, I don't know if it was in divorce or custody or in family law litigation, but if you run a search on my website or on my YouTube page, and just type email, you should come out. There's two parts I did early 2020 during the early stages of the quarantine. And it goes a little bit through what we just talked about recording and making calendars, but it goes also in the depth about how to document these issues and save them for later retrieval. Not that I'm encouraging unnecessary litigation or hostility or conflict, but unfortunately that's just part and parcel to many of these cases, and I want to make sure that you're prepared for that. Negotiate important provisions into your divorce or custody agreements. Sounds almost commonsensical, but you'd be surprised. Not only do people not think about certain things, but quite often, especially in divorce cases, you're doing a final agreement long into a process that may have been very difficult, costly, tiresome, and long. And you're often just happy to be getting it finished. So you don't either contemplate certain important provisions, you may not be willing to put more time and money into it. The other person just may not be willing to discuss them any longer, but it doesn't change the fact that the ones I'm going to mention now are significant, should be considered, even if it's going to be to say in our agreement we didn't consider it, but something that shows whether or not it was discussed, what the intention of the agreement or lack of agreement was, and what you think will happen in the future. So the first and most significant issue is relocation. Relocation is a very taxing issue and very common in our current society. We're very mobile. I think post-COVID quarantine issues with changing ability to work from home and people giving up commercial space, people may be moving to cities or even new states in ways that they didn't foresee before the quarantine occurred and may not have contemplated relocation. Relocation is complicated. It actually, the standard has recently changed you'll see there's a Bisbing versus Bisbing case if you ever research relocation. I actually represented Greg Bisbing in the trial court that led to the Supreme Court's change of the relocation standard, and essentially it's now the best interest of the child. But it's important to consider this issue when making a custody agreement, probably more so than most others that I'll mention after this, because it's a significant change of circumstances and greatly will impact your relationship with your children. So you want to put in provisions such as whether or not you or the other parent can or can't move, what distance you do consent to, because it's also important to realize relocation is usually discussing out-of-state relocation, but in-state relocation in New Jersey can also be very significant because you can live in North Jersey, like Essex County or Bergen County, and have a parent want to relocate to Camden County, which is, an hour or two away. That's still New Jersey. Doesn't trigger the same kind of review of relocation. There's a new standard on that issue. And again, I don't want to go too deep into relocation because it's a very significant issue. Again, you will find a webinar and probably several videos that I did on this topic on my YouTube page. I don't think it's on my website page, but my video consultation room at micklinlawgroup.com may have some information on that also. So you should check out both of those. Next is what we call the right of first refusal. And I kind of hate using this term because it actually comes from real estate. So it makes me think it's, dry and contractual, but it's basically saying that you're agreeing, if you had this language in your agreement, that you or the other parent has the right to your child or children when the other parent's not going to be available, and vice versa. Usually it has to cut both ways. So if let's just say you're not the custodial parent, the other parent has custody. If that parent's going to be away for a certain amount of time, you may or may not want the right to take your child during that time. You also may not want to have to give your child up every time you're going to go to the mall for an hour or two. So I usually recommend defining what time frame is appropriate for the right of first refusal. It can be if you're going to be away overnight. It can be if you're going to be away for several hours. I usually don't recommend making it too rigid. So less than 3-4 hours, probably not, because you may want to go out to dinner and not have to worry about right of first refusal. And remember, it goes both ways. It cuts both ways. So you have to provide notice to them and give up your parenting time. It's usually not good. So most of the time it's going to be overnight. Sometimes even overnight's a little rigid because you may have a relationship where you're going out for the night. You may have your mother or a babysitter watch. So it could be a weekend. But it's what's best for you and what the other parent's going to agree to. So I'm just kind of speaking from what I see being problems that arise if they're too rigid of a provision. But sometimes that works. That's why that I've seen them so often. You want to have a schedule that allows for FaceTime and telephone contact. If you have, actually, I was going to say if you have less than equal parenting time or a traditional, and when I say traditional, I mean like an alternating weekend, other holidays. But I think even when you have equal time, FaceTime and telephone contact when you don't have time is important. How often and how long, I think, will depend on the amount of absence you have between your parenting time and your phone calls, as well as the age of your children. If your child's 1 or 2, you want to see them develop, but you're not going to have a lengthy phone call with them. If they're 14 and 15, they're not going to have a long phone call with you. Anything in between is where you have usually a more rigid calendar, every other day, maybe half an hour at certain times. You want to build in vacation time, not just summer, but also school vacations, how you're going to alternate that. You may also want to consider where you may be traveling for vacation, because the law in New Jersey says you cannot remove a child from the state without either the other parent's consent or a court order. And that can be problematic if you want to go to Disneyland and you have a difficult ex-partner. And you don't want to always be running into court to get orders to go to Disneyland. So if you know where you're going to be traveling or likely to be traveling in your future, you can build in that area is an exception to the rule that you can't leave without permission. Because, for instance, ironically, if you drive 2 hours to Camden County, that doesn't matter. But if you drive 15 minutes from Verona to New York, you've broken the law. Not really what was intended by that provision. So it's not intended to prevent you from going on vacation to New York for weekends, prevents you from leaving and going to Greece and not coming back. But the law hasn't really caught up with that and still says you can't leave Jersey without permission or a court order. So build in where you know you're going to go. And you can even consider building in, again, reciprocity, like the other side, build in where you know they're going to go so that you don't have a lot of conflict. As a side note, that can be a significant issue. I'm not suggesting that the risk of somebody fleeing the country or not returning is not real. It is. Just because you have a good relationship and the person, you're agreeing that, for instance, I'm using Greece just as an example, they can go to Greece every year and not worry. There could be an issue, but they're coming back. Something you want to look into as a side note, again, another topic I'm not going to dive into, but you want to read about the Hague Convention and see if it applies to the area where the other parent is looking to go. The Hague Convention is an international treaty that covers custody issues for, I'm not going to say kidnapping because you can't technically kidnap your own child, but it deals with how to return the custody of a child who's been taken from the jurisdiction by another parent. And some countries subscribe to it and others don't. So it is important to recognize if the areas you're discussing apply or not. Requirements to consult with the other parent. Again, this is about long absences, about travel, but also important decisions like education, religion, medical, residence. Although it's implicit that these issues are supposed to be discussed with either parent, you want to spell out all of this to make sure that both understand it. It's not enough that the law says that you're entitled to it or you should do it. You want to make sure that both of you understand that you're entitled to it and should be doing it. And lastly, the most important thing that I always stress to people is build in times to reevaluate this agreement. People think that when they make one agreement, in a couple of years when things change, they can simply make another agreement. That's not the case. First, the law doesn't say that. And second, the other parent may not agree to that. So people commonly think, for instance, that as a child ages or switches schools or has religious events approaching, that the law will recognize that this is a change that needs to be addressed. But it doesn't. The law actually fails to recognize the aging of a child as what we call a material and substantial change of circumstances, meaning it doesn't matter how old your child was when you made the agreement to how old your child is now if you want to change the agreement. So I always recommend you put in certain periods of time or dates or religious events that trigger the right to review it. It could be when a child starts or finishes a school. It could be an age for a religious event. It could be in the event of relocation or change of education. Whatever it may be in your situation, you want to consider what's going to happen and build in specific provisions that say when you can and can't review the agreement to address these issues. Next is the area of custody that I hate the most. I have since I became a practicing attorney, and it's the tender years doctrine. Fortunately, as this slide indicates, it's largely been eroded. So before I go into tender years doctrine, and I may have a slide in the future coming, is a archaic law that says simply a child is best suited by being with its mother. And this goes back historically to the time in our country when women couldn't work or own property. Men were the main breadwinner. Women were the main caregiver. And maybe at that time it was appropriate, but it certainly isn't any longer, although it technically is still, quote unquote, on our books. The law, however, has adapted to saying that there's a presumption in New Jersey that a parent, both parents, are entitled to as much time as possible with his or her child. Now, my slide says as close to 50-50 as possible. It's really not that way. It's actually as much time as possible. That could be 60-40, 70-30. It might even be 80-20, depending on what is available. And there's a lot of reasons why that would be different. So just because you want 50% of the time doesn't really mean that you should have it. And if the other parent wants it, doesn't mean they should get it. If you're working 4 days a week and you're not going to be home, it doesn't make sense to have your child those days if the other parent's available. Sort of goes back to the right of first refusal I was talking about. For instance, you may be or the other parent may be a police officer or a fireman where there's like 4 on and 3 off. They may want their 3 off to be the times they have custody, and they may not want custody on the 4 days. And that may work and that may not work, because that also allows them to be the fun parent and not having to deal with custody issues because they're working. That may or may not work. You may have a parent who travels a lot and may not want to have custody during their travels. They may want to have custody during their travels and let their mother or a babysitter watch the children. You may or may not agree with that. So to say it should be as close to 50-50 isn't really accurate. It should be as much time as available. So I usually try to work to have both sides get the time where they would be able to be with their child. It shouldn't be I got to have 4 days because I want to have equal time. It should be really what's going to be the best for everybody involved. And that's in a perfect world, because obviously not everybody's going to think that way. And that's why we go through things like telling you there's no longer a presumption that mom gets custody. And it doesn't need to have a primary parent designation. And again, I'm going to say that it's a lot of women, because of the nature of my practice, feel that they need to have this designation, whether it's because historically they've been raised to believe this. A lot of people talk to their friends and family and they hear these horror stories and they think it's important. I generally recommend doing your best to stay away from terms: parent of primary residence, sole legal custody, physical and residential. Everything means something different, but ultimately it should just matter your time schedule, how often you're involved, and the relationship and communication between the two of you. If there's a designation that one person is parent of primary residence, yeah, it may matter for tax return filings and it may matter for school registration, but those issues can be addressed separately. Throwing the term in because somebody wants it or taking out because you don't want to give it doesn't really make any sense. It's not going to serve either of you. Watch your language and behavior. Not that I'm here to act as somebody's parent, but first, the court's going to expect and demand that you be able to co-parent. It's actually one of the main significant factors in a custody evaluation. So when a judge is evaluating custody, if your issue is actually going to be before a judge, he or she will be determining custody based on about 14 different factors. One of them, and most significant, is whether or not you can co-parent. And as I'm telling you earlier, to keep records and record conversations, for instance, the other person may be doing the same thing and have a plethora of evidence that shows that you cannot co-parent or they did not co-parent. Next, never speak negatively about the other parent to the child. First, it's bad for the child. Tell all my clients, children want to believe their parents are superheroes. So the moment you say something negative about the other parent, it hurts the child. You may not realize that. You may not even agree with me about that, but I'm fairly certain it's accurate, and it's not only a mistake for parenting your child, but it's certainly going to hurt you in court. Children understand a lot more than people give them credit for, and as they get older and develop more language, they're able to enunciate what they experienced both when they were younger and as they get older, and it often comes back to haunt you in your relationship with your children as they grow up. But all that aside, because I'm not here to tell you how to parent, it's certainly going to hurt you in court if it's discovered that you've been doing that. Watch your behavior. So first, I always say avoid anything that you won't want to have to explain to a judge. That can be anything, and we'll go through some specifics, but that could be anything from a drug habit to nasty email. It amazes me how often people still leave harassing or threatening voicemail messages or send text messages, which you are taking time to write. So you could stop and contemplate the language that you're using, because people are doing it obviously in the heat of the moment about a certain, one of the most significant issues that they're dealing with. And they sometimes just don't have the control necessary. We all do it. But you have to be mindful that your conduct is going to be reviewed by other people in the future when determining whether or not you should or should not have custody of your children. First is alcohol use. Now, the good and bad about alcohol is it's hard to track. If there's going to be issues about blood tests, it doesn't stay in your system long. Not that I'm encouraging you to drink around parenting time, but the problem is it's hard to disprove that allegation. So when it comes to issues about drug use, courts will always, always defer to the best interest of the children, which means if one person alleges the other has an alcohol use, they're going to take steps to find out whether or not it's true. Now, it can be unfortunate because sometimes it's used as a weapon, and you're on the defensive side of something that you weren't planning for and that isn't true, and it's not a comfortable position to be in, but you're going to have to. There's no way, and I've been dealing with this for decades, there's no way to say, Judge, this person has no proof, I shouldn't have to be on the defensive, because they don't care about either of you, they care about your children. So they're going to make sure that this is not an issue. Next, drug use. And this doesn't just mean cocaine and heroin. It also means marijuana, which is a very important issue now because it is technically legal in New Jersey. So a lot of people think, well, it's legal, I should be able to use it and not have an issue with it. But remember, alcohol is legal too. It's not a question of being allowed to use it. It's a question of you shouldn't be using it when you have custody of your children. The problems that we're going to see similar to the issue with alcohol is it's hard to test for it, but this is the opposite problem. Alcohol doesn't stay in your system long, so it's hard to tell by a drug test when you used it unless you just recently used it like the night before. Marijuana, however, can stay in your blood for weeks, if not a month or so at a time. So if you're tested for it, it's hard to determine when you used it in relation to custody and parenting time. But remember, just because it's legal doesn't mean the courts don't care about it. So realize this, and you want to talk to maybe some professionals, some counselors, and some lawyers if you have an issue that you're using this lawful substance, but it may impede your parenting time and custody issues. Corporal punishment, basically using physical punishment for your children, ironically is not unlawful. Not that I'm encouraging you to do it, not that I'm saying it's an appropriate way to parent, but it's not unlawful. Excessive corporal punishment is unlawful. Now, what that means, hard to define. There's no bright line test, so best to avoid it if possible, because you certainly don't want to find yourself in a position of having to prove or disprove whether your punishment was severe enough or not. But it is important to realize the mere allegation of it is not sufficient to eliminate or change parenting time. But the allegation itself can lead to the involvement of DCP&P, formerly known as DIFUS, for investigations. And the mere allegation of it and investigation can impede your current and future custody rights. So be careful. Domestic violence. Domestic violence. And when I say domestic violence, I don't just mean the issuance or receipt of a temporary or final restraining order, but the act or commission of domestic violence, proven or unproven, will impact your custody. If it's, and this kind of goes back to the corporal punishment also, if you're believed or perceived to be violent or abusive, it will certainly impact your children. Abusing a person or another parent abuses the children. They are considered victims by being involved, by being around it, by witnessing it. They are victimized by it also. Now, if there is a final restraining order that issues, well, actually a temporary or a final, the temporary will also give temporary sole legal and physical custody to the other parent. And a final one carries a presumption of sole legal custody because it presumes that the battered spouse or the abused spouse is not able to negotiate equally with his or her abuser. So they're not going to be able to co-parent. So they're given the presumption of sole custody. Now, when I say presumption, it doesn't mean that a restraining order says you have sole custody. Most judges, in my experience, try to avoid actually giving sole custody because generally they don't believe it's in the child's best interest. But it's there and it can be written, and in a confusion, a battle, or an ambiguity, it's going to be interpreted that way. Alienation. Alienation is a big buzzword right now, and it's used often in webinars and emails and arguments. My understanding is New Jersey case law does not actually recognize that term as a custody issue or an effect, but it is, and it's very real. The thing about it, first of all, to understand, if you're committing conduct that could be alienating another child, you can lose your rights to custody. If you believe the other parent is taking steps to alienate your child or children, you should take steps to end that as quickly as possible. Again, I don't want to go deep into this. It's a very intricate issue. I have done webinars on it that you can find on my YouTube page, how to address it, how to recognize it. It is effective, and fortunately, for lack of better words, it also takes a very long time to be effective. But you'll see the early signs of it, and that's when you should start acting to counter it. Lastly, don't use the children as pawns. It's often difficult for parents to see how they're involving their children. It's not just things that they say to their children, but it's negotiating against the other side, keeping parenting time or keeping things from the other parent because you're angry or upset. Even having conversations when your children might be close by, leaving mail out on the counter, letting them see things, even if it's unintentional, involve the children and will impact a judge's view about your ability to co-parent. Along the lines, keep your composure, avoid outbursts. Like I said, it's shocking how many people will send emails and text messages, as my next slide is showing, without realizing that somebody's going to read it. And that's why I tell my clients, write as if somebody's going to be reading it and speak as if somebody's going to be listening to it, because you never know when you're being recorded. As I mentioned, New Jersey is a one-party state. I put it up again because it's a very important issue. Both consider the legal issues I'm talking about, being one party, as well as the attitude a judge may give you for recording. So determine if it is going to be fruitful and in your best interest to do so. One issue I didn't talk about before, so I have a slide up here about it, is it's often helpful to avoid allegations of domestic violence. As I mentioned a moment ago, that is a significant impact to custody rights. If the other parent's going to be accusing you, having recordings showing that it's not true, you're not abusive, and or the other person may actually be the one who's abusive, will be significant in disproving that and ensuring that you have and maintain your custody rights. So my last slide is about questions, because again, we do this normally with a live group, and this is the first time I'm doing it without one. So here's the website, micklinlawgroup.com. You can also go online. My email is on my website, but it's brad@micklinlawgroup.com. Phone number is 973-562-0100. That also is for text messaging, so that you can get to an attorney 24 hours a day. Hope the information helps you. And if you have any questions, like I said, contact me. If you have any information or topics you would like me to cover in the future, certainly let us know about that also. Best of luck and stay safe.